This is Dimitri Lascaris for The Real News. Montreal-based Resolute Forest Products, Canada's largest logging company, has commenced a highly controversial $300 million lawsuit against two leading environmental organizations, Greenpeace and Stand.Earth. The lawsuit has been brought under a U.S. federal statute, the Racketeer Influenced and Corrupt Organizations Act, or RICO. As its name suggests, RICO was enacted in Congress by 1970 with the primary purpose of strengthening criminal and civil penalties against those engaged in organized crime. Among other things, RICO entitles a successful plaintiff to an award of treble damages, or 3 times the amount of damages that the successful plaintiff has actually sustained. Thus, the consequences for defendants who are found liable under RICO can be devastating. And precisely because the consequences can be devastating, those who are sued under RICO have no alternative but to expend prodigious resources in the defense of the RICO suit. When the plaintiff is a wealthy corporation like Resolute Forest Products and the defendants are not-for-profit environmental organizations, the mere cost of defending the lawsuit can be crippling, a fact of which a company like Resolute Forest Products is undoubtedly aware. RICO requires the plaintiff to show, among other things, that the defendants were engaged in a criminal enterprise. What does Resolute allege the defendant's criminal enterprise to be in this case? Publicly criticizing the Montreal-based forestry giant's logging practices in Canada's boreal forest. Now here to discuss this RICO suit with us is Todd Paglia, Executive Director of Stand.Earth. Todd has helped to transform the paper policies of multi-billion-dollar Fortune 500 companies. He was chosen as one of Ethisphere's magazine's 100 most influential people in business ethics, and before joining Stand.Earth, Todd was an attorney for Ralph Nader, focusing on consumer protection issues. I should point out that Todd himself has been named as a defendant in Resolute's RICO lawsuit, and he joins us today from Bellingham, Washington. Thanks very much for joining us, Todd.
Thanks, Dimitri. Glad to be here.
I'd like to start, Todd, by discussing the nature of the criticisms that Stand.Earth and Greenpeace have articulated against Resolute Forest Products. What precisely are the practices that the two organizations have criticized?
Nothing out of the ordinary, and nothing that you can't see if you actually tour some of the areas where Resolute operates. We're talking about very large clear cuts, the type of logging that makes it very difficult, if not impossible, for caribou and other wildlife to survive. And the criticisms that we have leveled against them are pretty typical of what environmentalists all over the world say about giant logging operations, which makes the lawsuit all the more quixotic and surprising.
It is the case, however, I believe that Greenpeace in 2013 felt obliged to apologize for some of the accusations it had leveled against Resolute. What happened there?
So, my understanding, more as a bystander, I wasn't a part of that, but Greenpeace has produced quite a few different reports on the effect that Resolute is having on the forest and on other issues. And in one of their reports, there were a couple of mistakes on GPS locations and characterizing what was happening on the land. And Greenpeace, like a lot of advocacy groups, was quick to recognize its mistake and retracted it and apologized. And Resolute was satisfied with that until some months later it decided to bring a lawsuit anyway. So, in the normal course of business, mistakes will be made. I think the important part is to correct them, retract them, and get the right information out there. Greenpeace did all that. And despite it, Resolute saw an opportunity to bring a massive lawsuit against them.
And am I correct in understanding that Stand.Earth itself has not withdrawn any of the criticisms it has articulated against Resolute?
Not in the least. In fact, we've redoubled them. But Resolute's hope with this lawsuit, I firmly believe, is not to win. Legally, they face a very uphill battle. I think their hope is to outspend us. And to give you a sense of scale and why we consider this to be a serious bully activity, I've compared Richard Garneau, the CEO, to being the Trump of Canada for this very reason. Give you an example. The company in 2015 had more revenue in the first 8 hours on January 1 than Stand.Earth had for the entire year. So the financial wherewithal is quite skewed, and they're hoping to just spend us into the ground. That's the strategy as far as I can tell.
And since we're on the subject of strategy, I noticed that the company brought its RICO suit in, of all places, the United States Federal District Court in Georgia. Why did it choose to pursue its action there? And where is the lawsuit likely to be adjudicated at the end of the day, in your view?
Well, yeah, that was quite interesting. It's about the hardest place we can get to. So very expensive, labor intensive, time intensive for us to get there. And in fact, I have never been to the Southern District of Georgia. So they were very strategic in trying to pick this location. They also picked it because they have a mill, and there's a lot of sympathy towards paper and pulp and lumber mills in the Southern District of Georgia. That entire strategy, though, backfired in a major way last week. The judge in the Southern District of Georgia couldn't figure out why on earth Resolute thought it could bring a lawsuit there where many of us, including me, have never been, and he removed the case to the Northern District of California, meaning San Francisco.
Right, and those decisions, you and I know as lawyers, are discretionary, and therefore getting them reversed on appeal is a considerable challenge.
I think there's almost no way that can happen here. I think Resolute tried to sort of overthink this and find the most difficult, most expensive venue possible for us, with the friendly jurors and hopefully a friendly judge, and they got bounced out of there. So now they're welcome to San Francisco, slightly different jury pool, different judges, and Greenpeace and Stand.Earth have offices in San Francisco, so it's much easier for us to wage this battle from there.
Now, you and the other defendants have brought a motion to dismiss this controversial RICO suit. And in your motion, you describe the suit as a SLAPP suit under Georgia law. What is a SLAPP suit, and what are the primary arguments the defendants make in support of the SLAPP suit? And one other thing, what would the consequences be for Resolute if the court accepted that this was a SLAPP suit?
So a SLAPP lawsuit is a strategic lawsuit against public participation. It's a tried and true method of giant companies trying to silence their critics. And it is usually a trumped up series of charges meant to cost an awful lot of money for the nonprofit to defend against, even if it's meritless. SLAPP statutes, however, cut these things short, and it allows the judge, in this case, judge in San Francisco, to look at whether or not there are actual merits in the case that are likely to succeed, and if not, to end this case very early. So we think, even in the Southern District of Georgia, our motion to dismiss was very strong, and Georgia recently adopted an anti-SLAPP legislation. California is the leading jurisdiction on anti-SLAPP suit legislation. So we are feeling like we're in a very good position. What's at stake here, though, is really big and much, much larger than Greenpeace and Stand. What Resolute is doing is they're not just bringing this lawsuit and using RICO to try to silence us. They are advocating this as an approach for other industries. They are saying to other industries, follow us. And if you look online, they've had Steve Forbes write about this, they've had the Financial Post write about this, and other conservative outlets. And they're saying this is a way to silence those pesky NGOs and people who criticize us so we can keep business as usual. And so there's much more at stake than just me being sued personally, my organization, and Greenpeace. And that's why we're fighting this as hard as possible.
And precisely because of the stakes, I understand that a number of organizations have filed briefs as friends of the court in support of the motion to dismiss. Who are those organizations, and what are they arguing?
There's a number of very big, persuasive NGOs have submitted, and I think most interestingly, unsolicited by us, a group of reporters organizations and news outlets filed an amicus brief saying that this distortion of trying to use RICO to essentially attack the First Amendment cannot stand. And the interesting thing about that is they're, of course, arguing, very hardcore First Amendment protections that are well established in U.S. law. Resolute is trying to find an end run around the First Amendment. I think they're not going to find it. But the interesting thing is many of the news outlets that so value the First Amendment and that have come to our defense, in fact, might be buying pulp or paper from Resolute. And that's something that we are beginning to communicate to them about. And they're going to be, I think, forced to make a decision between favoring either their values or pulp produced by a company attacking the First Amendment. So I think for book publishers, for newspapers and magazines, there's going to be a bit of a reckoning on whether they're going to live their values or leave them by the wayside and continue to do business with Resolute.
Well, this is undoubtedly a piece of litigation which is going to have very considerable implications for the environmental movement and for free speech. So we'll certainly follow the story, Todd, and we thank you for joining us today.
Thank you, Dimitri.
And this is Dimitri Lascaris for The Real News.